Our next two cases will be called together, the 18P0169 and 18P1364, AM versus RM. We're going to hear all of your arguments. We're not going to do them.
Okay.
So for both appeals, you'll argue, and then your brother will argue in response.
Fine.
This is impounded, so I ask that you only use initials.
Absolutely. Good morning, Your Honors. My name is Karen Galat, and I represent the husband and the father in this case, known as RM, and we're here today before you for two separate reasons. One, we believe that there are orders in the judgment of January 10th, 2018 that are inconsistent with certain statutes, rules, and case law. Second, and this is from Williams versus Massa, we believe there is a considerable discrepancy between the trial judge's findings and her subsequent orders. Combined, we believe they warrant a reversal of this case. Very briefly, the parties were married in August of 2008 after dating for a couple of years. They have two children who were, at the time of the trial, 3 and 5. In early March of 2016, AM returned from an extended trip to California and demanded that RM vacate the marital home. When he refused, she went to the Topsfield police station. She told them, although RM had never touched her, she was in fear of him. A few hours later, she had a 209A restraining order, and my client was vacated from the marital home. We are not appealing the 209A order simply because there was no space for us to do that. However, we want to point out that AM's entire case has been based on her alleged fear of RM and her testimony that RM was aggressive and angry. This was largely unsupported except for testimony from AM's parents. However, the two therapists who testified at the trial suggested otherwise. You'll find the testimony of Dr. Gosnell on page 185.
Doesn't that then create a credibility determination?
It probably does, Your Honor. I'm not going to suggest that it doesn't. But the issue of whether or not Mr. RM was at any point angry, and the issue of whether AM was in fear did not really play at all in the trial of this case in any manner other than the allegations made by her and her parents. For example, in the issue on the joint funds, we have quite simply testimony of AM, testimony of RM, finding 55 of the trial judge, finding 97 of the trial judge that belie the entire conclusion the trial judge reached. Finding 97 is that RM began paying the marital bills when the children were born. And finding 55 from the trial judge states that AM resumed this obligation in June of 2016. RM testified that he paid the bills, the marital bills, for March, April, and May of 2016. During this period of time, the first restraining order was in place. He could not contact AM, but he checked on their bills, and they hadn't been paid.
You know, again, though, this is a credibility question, right?
I don't think it's credibility, and I'll tell you why, Your Honor, because the judge made a specific finding that there was this period of time when RM paid the bills, starting when the children were born, and a specific finding as to when AM resumed paying the bills. In between, we have those 3 months. And those 3 months are the only 3 months that are in question.
Doesn't AM say that only RM had the ability to remove the money from the child's account?
No. The parties both had the ability to access the joint accounts, and then there were two.
And she said she did not do it.
She said she didn't take the money. He never said that he did not take the money. He acknowledges he took the $27,000.
And Why was the judge required to credit his testimony that he used it to pay bills?
Well, if she didn't want to, let me suggest to Your Honor that there's no other possible explanation, because the bills were paid. Nobody ever disputed that. AM stated she didn't pay the bills until the beginning of June. So if the judge understood that RM paid the bills starting when the children were born and that AM started paying the bills in June of 2016, it stands to reason that the months...
Were they without any other source of income that required RM to use the child's college savings account to pay bills with?
It wasn't the child's college saving, Your Honor. I want to make a distinction. There are two Cantella accounts that are the children's college savings accounts. They were never touched.
Were both liquidated?
No. The children had joint savings accounts with each parent. They also had college savings accounts with Cantella, and those remain in place. They were never touched.
What was the accounts that had the $4,000 each in them?
I believe it was closer to $2,000. So the total that the trial judge ordered RM to repay was $4,500, and those were just joint savings accounts that the parties had with their children. And then I think if you look at the trial record, this is my recollection, is what you're going to find is that RM testified that at periods of time when they had more significant amounts of money, they would transfer those funds to the Cantella accounts, which are like 529 accounts. So those are the accounts that are for the children's college, not the joint accounts that were with the children. Plus, most of the money came actually from joint accounts between the parties. And as I stated, if RM had not paid those bills, there would have been a question as to who paid them, because AM stated she didn't start paying the bills until June of 2016, and the trial judge made a finding in that matter. In fact, AM only made one reference to a case in opposition. It's inapplicable. It was based on unjust enrichment. This is really a situation that's based more on the facts. Rule 411 is inapplicable because this occurred before my client was served with the complaint for divorce, and also he used the funds for the ordinary and necessary living expenses of the parties, mostly at that point in time being AM and the children. He was already out of the house, and if you look at his financial statement for that period of time, which is in our trial exhibits, you will find there is no way he could have paid the marital bills without accessing the joint funds. He was not making enough to even support himself. He had a small apartment, he had his own car, and so on and so forth. And again, he couldn't contact AM to find out if she was going to pay the bills. So if Your Honor's comfortable with that, I will move on to the attorney's fees. This is, unlike my prior section, completely fact-based. The DiMatteo case makes it clear that the trial judge has a great deal of discretion in awarding attorney's fees, but she's cautioned by Pemberton and by Kane that prudence is required, and the award must be screened on its own merit. So she made no finding anywhere in the case that RM engaged in protracted litigation. She never considered the respective financial positions of the parties. She included in her award of fees several contempts in which RM was given all of the relief that he sought. I think, frankly, he should have been awarded fees for those cases. The cases cited by AM in her red brief are applicable. They are numerous, Your Honor. I'm not going to list them here, but on page 13 of our gray brief, you will note that I applied each case and suggested for you why each case was inapplicable. So we're asking that the award of attorney's fees be reversed. In the property division section, once again, we're back to a situation where the trial judge she was actually ignoring her own findings when she entered orders. She did look at all of the factors under Section 34, as she's required to by Hasse. She made some mistakes which were really de minimis. Some dates were wrong, things like that. But she also made some much more significant mistakes. Number one, RM and AM both had retirement accounts when they got married. AM's was $100,000 less than RM's. However, they were all lumped together when she made her final findings in this case. Second, and I think probably more important, AM contributed more to retirement during the marriage than RM. This completely belies trial judge's finding number 98, in which she states that it was the opposite, and this really skewed the asset division in AM's favor. AM's contribution was almost $14,000 greater than my client. And the other thing is that the trial judge ordered in her judgment over the course of the entire judgment for RM to pay to AM over $100,000. But when she divided the property, she completely ignored what it was going to cost him to borrow that money, which he did from a HELOC on the marital home. She misconstrued the parties' liabilities from their financial statement, just a little bit, a couple of thousand for AM and over $40,000 for RM. And probably the most significant importance here is that she ignored RM's ability to earn future assets, and in her findings she stated that the RM has raises each year of $100,000 to $300,000, and she specifically stated that he does not have the opportunity to earn commissions and bonuses that form such a huge part of AM's income. Actually, that particular year, close to $100,000. So RM is asking at this point, pursuant to cases like Rice and Putnam and Denninger, that you reverse the issue of marital assets for further findings by the trial court. There was a GAL in this case. Your Honors, he recommended the parties share legal custody, but the trial judge ordered that AM have sole legal custody. But the trial judge never made findings as to why, and we suggest that based on cases such as Bauer and Ventries, her order was inappropriate, and it was made without consideration of the children's best interest. She found in finding number 68 and also exhibit page 364, the last 6 lines, that the parties had communicated effectively by the use of Outlook, Our Family Wizard, by telephone and in person. This was also the testimony of AM, and that is cited in our brief. Both the GAL and the trial judge acknowledged the children were comfortable with RM, and that's her finding number 90. And the testimony of witnesses whom RM and AM socialized with during the course of the marriage, the Cantelmos, Dr. McCarrick, Pablo Samuel, and Kim Drake, all spoke about how close the children were to RM and how they loved to spend time with him. So if you look at the Doe case and Mason versus Coleman, it would seem to me these are the very bases for shared legal custody to begin with. And of course, Chapter 208, Section 31 and 31A makes it clear that in the absence of misconduct, there should be no presumption in favor or against shared custody. There was no misconduct in this case. AM alleged she was in fear. Her parents backed her up, but RM did nothing wrong. The mere existence of the 209A without more is not supposed to be determinative of shared custody. And even here, the trial judge indicated the conflict between the parents surrounded their separation in March of 2016 and did not relate to the children. Again, I draw your attention to page 364 of the trial exhibits. But even so, she stripped RM of custody, shared parenting, and according to Bouchard and Carnivallity, she seemed to be punishing him for what she perceived as bad behavior. So on page 28 of our brief, we cited 10 cases, including Friedman, that indicates that there are limits on an appellate judge's, there are limits to appellate judge's deference to a trial judge's award of custody, and that it won't be sustained without clear findings that it's in the children's best interest. All factors have been considered, weighed, and the underlying facts supported by the trial judge's conclusions. We maintain in this case she was simply wrong, and RM implores this court to reverse the order for sole legal custody, not just for himself, but also for his children, who have been deprived of the myriad of contributions he makes as a father. On the issue of alimony, Your Honors, based on the Alimony Reform Act and cases such as Denninger and Gruber, we believe that AM should have been ordered to pay RM 32.5% of the difference in their income after child support was factored out. At the time of the trial, that was $639 weekly, not $134 weekly, which is what the trial judge ordered. Since the original alimony order was entered before the tax law changed, it will continue to be deductible by
When you came up with the $639, do you subtract the income that's used for the child support calculation?
I did. So when I did that calculation, I actually subtracted that from one income and added it to the other to balance the two.
Okay.
So,
and can I say on the child, and is there an agreement on the party now on the child support order?
There is, Your Honor, and just to let you know, I brought with me today, but I haven't filed them. I just brought them, the financial statements. I realized I hadn't submitted them. I didn't know if you wanted them.
No, we don't. We can't make findings. But if you've got agreement,
you have the agreement, and I know that Mr. Mielek joins me in asking that the court allow the child support modification to enter.
So I don't understand why we have to allow anything.
I see that in the rule, Your Honor. So my understanding is if there is going to be a modification while an appeal is pending, that it does not actually become final until Your Honors have approved it. That's the way I read the rule. Perhaps I'm wrong.
Well, you cite the Braun case, and my reading of the Braun case says you should let us know in advance so we don't spend effort reviewing that issue.
Right, which we did. We sent that in months ago. I hope it reaches.
And from what I can see, the probate court has entered the modified judgment.
Right. This was back in January, I believe.
Right, but I mean the modification judgment is signed by Judge Kaplan.
Exactly.
Yeah. So it's already been entered.
It is entered. So,
and we've been notified.
And you've been notified, and the parties are following it.
Okay.
So I don't know if there is another piece here.
All right. To the extent we need to adopt it, we will, but I just don't see the need for us to endorse anything.
It's a jurisdiction issue. With the court, the trial court's order isn't effective while the case is pending here.
That was my understanding. So
the main thing is we don't have to address the child support issues in the briefs.
Right.
Right.
That's fine. Right?
Well, yeah.
Your motion to allow the probate modification to the extent we have to allow it is allowed.
Thank you.
Right.
Belt and suspenders
that makes
from
sense.
our side of the.
All right.
Thank you.
Thank you very much.
So you wanted me to move at this point directly to the next section, which would be the next appeal.
No. Your time's up.
Okay. So
we have your brief. We understand the issues.
I thought we were going to be able to have
I explained this at the beginning.
So we were only given 15 minutes to argue both?
These cases were consolidated for the convenience of the panel.
I am so sorry, Your Honor. We were not notified of that. We did make a motion.
Excuse me. I mentioned at the beginning of the hearing. If there's something else that you'd like to tell us briefly, go ahead.
I have a completely separate 15-minute argument on the other brief.
I'll give you 3 minutes.
Thank you, Your Honor.
I did explain this at the beginning of the argument.
I misunderstood. I thought you were going to give me a double amount of time.
No.
Okay. So, the Meeting House Lane, I'm going to say that in this case, we have a blatant lack of fairness because on the one hand, the trial judge awarded AM a portion of RM's premarital assets, and on the other hand, we have an asset acquired by AM during the NISI period. There is no bright line case on the subject. In footnote 9 of Davidson, you indicated that perhaps more case law was necessary. Maybe this will be it. But I don't think at this point I'm going to say much more as to that. The May 30th issue of
You're not saying that you're not the affidavit from AM seems to say that there were two sources of the down payment. One of them was a gift from her parents. You're not entitled to any of that.
No, but
so it's whatever it's only, and your claim is that it was that the bonus was based on her work during the marriage.
Right.
Yeah.
And we don't know what the relative
right.
amounts of those two are. So as to the attorney's fees on May 30th, 2018, I'm going to simply turn your attention to my brief and leave it at that. As to the amended judgment in Rule 77, I found some very disquieting information in my brother's red brief. I imagine it was prepared by a person in his office, and he did not become aware of it. But there is a case in here that is cited, Altschiller versus Boston Harbor Marine, for the position that Rule 77 says X. And actually, that case doesn't say anything about Rule 77, not Rule 77 of civil procedure or domestic relations procedure. And they're a little bit different because civil procedure allows for electronic service, which we're not arguing.
You did get your claim is that you did not get notice from the court, but you did actually get actual notice, and you were able to timely file a notice of appeal, right?
I believe the docketing of the appeal was a little late. This court did allow it.
So how are you harmed?
I'm not sure that we are.
Okay.
I'm not sure that we are, but I do think that it is, except for the one thing, is that we never had an opportunity to return within 10 days, as would be required, to the trial judge to argue against the $1,000 of attorney's fees.
Did you try?
Yes, we were told that we would not be able to do that. This is informal. These are the conversations we have. She didn't want to hear anything about it. It was a done deal. And at that point in time, the order that she had made in the judgment of contempt, forget the paragraph 11 about the $1,000, was so incredibly severe that my client was in a position of scrambling to try to get money to satisfy the judgment at that point, because his motions for stay had been denied both by the trial judge and in this court as well. And I appreciate the extra time.
Are you all set? Is there something else you want to tell us?
I find that at this point in time, there's nothing I can do in 3 minutes. I will.
And that's why I'm giving you extra time.
I understand, Your Honor, and I appreciate it. I absolutely can rest on my briefs. The information that I've told you this morning is all taken from my briefs. I feel comfortable with what I wrote. I feel comfortable with the cases that we cited. I know that there is some question about the law when it comes to the Meeting House Lane property, the new property that was acquired by AM. And I think that is, there are cases that are instructive, but they're not on point. And I do think I pointed that out to you in my brief, and I want to emphasize that. We know that. We just are hoping that you will understand the real blatant unfairness of considering the premarital assets and giving some of those to AM from RM, and then denying our ability to proceed on the post-trial asset acquired by AM.
Okay.
Thank you very much, Your Honor.
You're welcome. Mr. Millick.
Good morning, Your Honors. My name is Jeffrey Millick, and I represent the wife and mother, AM. Obviously, there's a very high hurdle to overcome on a judgment like this. It's abuse of discretion standard. And I don't believe, for the reasons I've stated in my brief, that the appellant has been able to do that. Let me just start with some of the issues in the order in which they were presented to you. With respect to the court's order that the husband reimbursed the wife for half of the money he took out of the joint marital account, that was entirely proper, certainly within her discretion. And the evidence was that, and it's right in the transcript, I believe it's on page 1170, that the mortgage was paid from the joint accounts not from the money the husband took out of the joint accounts and put into his individual accounts. There was plenty of evidence there in the court during the trial for the judge to base her decision that he had improperly taken this money out, a ton of money, and not done anything with it of a marital nature. And the judge is empowered to make right early withdrawal of marital funds, and she did that here. The same idea is true of the child saver accounts. Both children had $2,000 or a little over $2,000 in their child savings accounts, and he took that money too. And the judge was entirely proper in ordering him
Those
to
were the
return.
savings accounts, right? Not the college accounts.
Yes, they were child saver accounts, and those were intended for the children. They were placed there for the children, and he took them out for himself, and he presented no evidence whatsoever that he used any of that money to pay joint marital bills. None. And so what the judge did there was entirely fair. The judge's order that the husband pay the wife over $600 to $700 in attorney's fees was also within her sound discretion. We had asked for more. We had asked for actually over $12,000. And she paid it not because I think my sister said that the husband prevailed on complaints for contempt. The 4 complaints for contempt for which he gave me fees, he lost. He didn't get what he asked for. He lost those. And one was against the guardian ad litem. So those fees were entirely reasonable for the reasons I stated in my brief. The asset division, Your Honor, which the husband complains about, was actually 56% in his favor. He got 56% of the marital assets. That's over $105,000 more than the wife got, and yet he still wants more. And he got more despite the fact that during the course of the marriage, the wife had contributed over $330,000 more in income to the marital partnership, that she had $36,000 more in debt than he had, and that she was the primary caregiver of the children during the marriage. During most of the time she was working. So I don't see any reason whatsoever for this court to question the trial court's judgment of asset division when the court gave him 56% under those circumstances. With respect to the sole legal custody, that's a critical issue in any divorce case. Before a court issues sole legal custody, the court needs to take into consideration what's in the children's best interest. That's the touchstone. And here the judge heard the evidence, not only from the parties, but from the mother's parents, from 2 caregivers, nannies, from a person who lives down the street and saw them at gatherings. And all those people testified about the way in which this man treated his children. And he was harsh with them. They all testified to the same thing. And the judge saw their demeanors and could assess their credibility. They testified that he was harsh. They testified that he placed this little boy when he was 4 years old outside on the porch in sub-freezing weather without a coat or socks as punishment. And not only that, he denied it. So it wasn't a situation where he had a bad day and said, you know what, I made a bad mistake, I won't do that again. He denied it. But the other people at the party saw it and they testified it happened. There were many other instances of abuse and poor decision-making by him as a father, which I've outlined in my brief and I won't repeat here. But the judge had entirely all the authority she needed to make a sole legal custody judgment to the mother. And I'll tell you, one of the most troubling things I think the judge found was that the children's pediatrician recommended that they have counseling because of the stress of the divorce. A pediatrician recommended that. And the mother was willing to do that, and the father wasn't. And he pocket-vetoed it. And awarding sole legal custody is the way you avoid pocket vetoes like that. That's not fair to the children. With respect to the parenting plan, the judge heard all the evidence, as I talked about, with respect to the manner in which the father treated the children, and she devised a parenting plan that was appropriate under the circumstances and in the children's best interest, and that was her job, after evaluating the witness testimony and their credibility at trial, and that should not be disturbed at this level. With respect to alimony,
Can I just ask, to what extent are those reviewable in the trial court?
I'm sorry.
Parenting plan and the custody issue. Yes. Can they be reviewed by the trial court judge at the request of one or both of the parties?
Yes. In the event in the future that there should be a change in the children's best interest, The father can file a complaint for modification, and what he has to do is show that there is a material and substantial change in circumstances warranting a change.
So they just can't rehash the same facts, but if there's some development or maybe the age of the children or something.
Exactly.
All right.
Because it's the idea that let's do what's good for the children now, and if it changes, they can change it. So with respect to alimony, the key factor on alimony, there are a number of them, but the key one is need. And it's just not need, it's need to maintain the lifestyle of the marriage. That's the idea of it. And here the testimony was that they lived a frugal lifestyle. They occasionally went on vacation, moderately priced vacations. They drove moderately priced cars. They did very little clothes shopping. They lived frugally. And the judge, after hearing all the evidence, both the testimony about their lifestyle and the financial evidence, she made a decision that in order to maintain the marital lifestyle, he needed X number of dollars for alimony. And that's what she did. She ordered that. There's nothing in the father's brief to suggest that that was wrong. Not clearly erroneous, not plainly wrong and excessive. Now, with respect to the 60B motion, the fact that a party earns more income after a divorce trial does not mean that the judgment gets undone, because everybody earns money after the divorce trial is over.
How do you respond to the claim that this was actually based on commissions that were made before the divorce?
Yes, and so I don't believe that that's the case. But here's the thing: you always get paid in arrears, right? So at least 2 weeks in arrears, basically, for your paycheck. But also, people who are on commission, they also might get paid in the future, and the judge knows that.
Right.
That was
there's evidence that there's some evidence that she was paid a year later, like the next year.
Right, but there's no evidence, Your Honor, as to what work she did or didn't do, when it was done, and in what way it affected the money that came in after.
Did the judge make any findings on the motion, or just deny it?
She denied it because there really wasn't anything to it.
It's opposed with an affidavit where your client says that this was post-divorce sales, and that's it. I mean, should they be telling some discovery or something like that?
No, it's not necessary. And when we try these divorce cases, Your Honor, we try them, date certains in court, and then life goes on. And if the court had to readjust all the evidence that came in during the trial based on the things that go on in life, their job of the judge would never be done. We'd be back in there arguing about this has happened, this has happened, this has happened, and nothing would be finalized. So the responsibility of the parties during a trial is to put into evidence the facts that they want the judge to consider. So if the husband wanted to put into evidence that there might be some income that the wife might be receiving in the future, and he wanted the judge to take that into account, it was incumbent on him to do it during the trial. But he simply can't come back later and say, oh, wait a second, let's look at this. Because the judge's job would never be done, and they are so busy the way it is right now, that would be a nightmare.
I know you mentioned commissions, but what about the purchase of the Meeting House Lane home after the judgment nisi, but before the judgment absolute?
So anybody can go out, and this happens all the time, because often when you get a divorce, somebody moves out of the house and they have to buy a new home, particularly when they have the children. So what she had to do was find a new home. She got a gift from her parents, which was fortunate, and that's not part of the marital partnership. And she also had other income coming in from whatever source, for whatever reason, and she had a right to use that. And the rights of the parties with respect to the assets was determined by the judgment. Now, there's always a lag time between the time of the last day of trial and the judgment. It can be as much as 4 to 6 months. And then we've got the nice-side period. So things are tacked down as of the time of trial. And as I said a moment ago, it's incumbent on the parties to advise the court at the time of trial what evidence they need the judge to consider. And
so just on that point,
sure.
So the commission bonus theoretical money that was used to buy the new home, that was an issue that was apparent at trial. There was an awareness of that as a potential, but it was never raised as to the potential future money that would have been the tail of the end of the marriage.
I guess the best way I can answer that is that the husband was well aware of what the wife did for a living, the money she earned, the basis for her compensation, and so forth. So if he was going to make an issue of that during trial, that was the time to do it.
So it's not new evidence?
It's not new evidence. No. And it's also money that came in because he got money after the trial as well. Everybody does. This is not uncommon in divorce cases where so many people have compensation based on bonus or commissions or some other form of something that's not every 2 weeks. And you don't simply go back and have a redo, a mulligan, because someone got a paycheck after the trial was over.
But in theory, he could have brought this at the trial and said, she's anticipated to get a bonus for the balance of this year that'll come after the theoretical divorce is over.
Absolutely.
And I should be entitled to half of that or whatever portion he thinks he's entitled to.
Exactly.
And that was not raised at trial.
It was not, Your Honor. So it's not fair to the judge to say, now, I didn't do it during trial, I want you to take up your time and redo it now. Okay? With respect to the
question of the stay, that was the husband needed to stay the judgment in the first case, right? That was the issue, but didn't make a timely motion.
So on this next issue about the attorney's fees, you mean?
Yeah.
So yes, he wanted to bring a stay. So there was a judgment. He was supposed to pay my client a ton of money. He didn't do it. So we had to, because of the history of this case, it was so litigious, the judge said, don't file anything unless you've got my permission. We asked for permission to file a contempt. And she said, yes, you can do that. Then she said, there's going to be a hearing on May 30th on this. But, husband, if you want, you can try to get a stay before that, but you've got to do it within 7 days before the hearing, in fairness to the mother, so she's not preparing and coming in here.
Right.
Well, he didn't do that.
Ms. was right, but you had to do that first in the trial court. You have to seek the stay first in the trial court.
I think you can do it either place, Your Honor. I think it's preferred in the trial court, but I think you can come here if there's a reason that you believe that you won't get it. But in any event,
or if it's futile or something like that.
Yes, exactly. So he waited 28 days before filing it. And the only thing I have to say 28 days is there's a letter dated May 21st, from counsel. I'm not sure whether it was mailed or not, but best case scenario was 28 days. And so he didn't get a stay. And so we showed up at the contempt hearing, and his counsel said, we want to stay. Now, the judge says, I'll give you the stay so you can go to the appeals court because I'm denying it. But if you're going to do that, it's not fair for the mother to have to pay her counsel fees for being here when you were supposed to get the stay earlier. You can't have your cake and eat it too. So she awarded my client $1,000, which was less than we requested, but that's what he's complaining about. And she had every right to do that. That's well within the judge's discretion in the probate and family court. And then finally, with respect to the validity of the amended judgment, as one of you pointed out earlier, he did get it. He knows what his obligations are. And there's no harm, no foul. I mean, if you get it, you get it. There's no evidence that it wasn't sent to him. And so it's clearly a valid judgment, and it wouldn't go poof anyway just because he didn't get it. He might get additional time to do what he needed to do under it if it was received on time, but it doesn't simply disappear. So those are my thoughts, Your Honors. I rest on the rest of my brief unless you have any questions.
Thank you. Thank you both.
Thank you.
With that, I'd like to thank our court staff, our court officers, our excellent timekeeper, and we will stand in recess.
Ms. Galat, hold on one second. Ms. Galat, in the motion, it's a minor thing, but the motion for our approval of the modification. No, in the motion, it just says the parties reached an agreement on September 30th, 2019, which hasn't occurred yet. Do you mean you reached the agreement September 30th, 2018, or?
Actually,
but it was dated another date.
January.
Okay.
I did not handle the matter in the lower court. I think that Mr. Mielek may be better able to respond to that.
Just so it looks like January 30th, 2019 was notarized.
Yes, and that's the date of it, Your Honor. I have a copy here if you'd like it.
So it's January 30th, 2019, not September.
Yes.
All right. Thank you.
Great. Thank you.
So sorry. All right.